Get ready for the dictation on the count of 3, 2, 1, start. In Union Territory of Pondicherry and ORS versus PV, Suresh reported in 1994 to SCC 70, the Supreme Court held that the court cannot alter the terms of the contract or rewrite the contract. The court cannot also evolve formula for determining installments payable under the contract in the absence of materials before it. The judgment was rendered in the context of proceedings under Article 226 of the Constitution of India. The proposition that the court cannot alter the terms of the contract or rewrite the contract is well established. In Makram, Barsoom, Stephanos and London and Leeds Business Centres Limited reported in 2011 EWCA CIV 1157, the Court of Appeal held that the general approach to the construction of documents was well settled. The court could not rewrite contracts in the context of establishing what the parties had meant by the language they had used. To quote the appeal court, that case is not a license for the courts to rewrite contracts. However, in this case, the appellants have not been able to demonstrate that the learned arbitral tribunal has rewritten the contract. Arbitrators are judges appointed by the parties and therefore an award passed by an arbitral tribunal is not to be interfered with lightly. It is well settled that in proceedings under Section 34 of the 1996 Act, the court does not sit in appeal over the award. It is well settled that in proceedings under Section 34 of the 1996 Act, the court does not sit in appeal over an award by reanalyzing the evidence. In PA&SPA Shares and Stock Brokers Private Limited versus BHH Securities Private Limited reported in 2012 1 SCC 594, the Supreme Court held a court does not sit in appeal over the award of an arbitral tribunal by reassessing or reappreciating the evidence. An award can be challenged only under the grounds mentioned in Section 34(2) of the Act. Therefore, in the absence of any ground under Section 34(2) of the Act, it is not possible to re-examine the facts to find out whether a different decision can be arrived at. Sections 34(1) and 2 of the 1996 Act provides as follows. Application for setting aside arbitral award. 1. Recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 and subsection 3. An arbitral award may be set aside by the court only if a. The party making the application furnishes proof that a party was under some incapacity or the arbitration agreement is not valid under the law to which the parties have subjected it, or failing any indication thereon under the law for the time being in force, or the party making the application was not given proper notice of the appointment of an arbitrator or of the arbitral proceedings, or was otherwise unable to present his case, or the arbitral award deals with a dispute not contemplated by or not falling within the terms of the submission to arbitration, or it contains decisions on matters beyond the scope of the submission to arbitration, provided that if the decisions on matters submitted to arbitration can be separated from those not so submitted, only that part of the arbitral award which contains decisions on matters not submitted to arbitration may be set aside, or the composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties unless such agreement was in conflict with a provision of this part from which the parties cannot derogate, or failing such agreement was not in accordance with this part, or the court finds that the subject matter of the dispute is not capable of settlement by arbitration under the law for the time being in force, or the arbitral award is in conflict with the public policy of India. Explanation: without prejudice to the generality of subclause 2, it is hereby declared for the avoidance of any doubt that an award is in conflict with the public policy of India if the making of the award was induced or affected by fraud or corruption, or was in violation of Section 75 or Section 81